Hello, my name is Ron Brand. I'm a professor at the University of Pittsburgh School of Law, where I am also the academic director of the Center for International Legal Education. At the center, we have been working with the U.S. Commerce Department Commercial Law Development Program for a number of years uh, to use the VIS, International Commercial Arbitration Moot, as a platform for legal education in the Middle East. And for the first few years, we then turned that into a Middle East pre-moot. And this is the 14th annual Middle East pre-moot that's being held at the ADGM, the Abu Dhabi Global Markets. And we are very pleased to have ADGM as well as the Bahrain Chamber for Dispute Resolution and others as our partners in this endeavor to help students better understand international commercial law and arbitration. You, as an arbitrator in the competition, are very important. You are key in that process. What I want to do is give you two things, a little information on two things. One, the process of the Vismoot, and two, this year's problem. So let's turn to process. Uh, First of all, uh, each hearing uh, is roughly 1 hour. Each team is allocated 30 minutes for their presentation, and that will be split between two advocates. One advocate will argue procedural issues, the other advocate will argue substantive issues for each side. Now, one of the first questions the panel should ask is whether the counsel have discussed with each other the procedure. And normally they will have done that before the arbitrators come into the room, and they will be able to tell you the order of presentations. Normally, and in this one, it probably makes sense for the procedural questions to go first. So you'll have, and it makes sense for the claimant to go first. So claimant on procedure, followed by respondent on procedure, followed by claimant rebuttal and respondent surrebuttal. Then when procedure is finished, the same process will occur with the substantive claims being presented. Claimant on substance, respondent on substance, claimant on rebuttal, respondent on surrebuttal. And each advocate will split his or her 15 minutes, roughly normally 14 minutes for the main argument and 1 minute for rebuttal, but they have uh, the autonomy to choose how they allocate their own time on that. But that should be established up front. They will then make their presentations. You should ask questions. That's an important part of this. You shouldn't take so much time asking questions that they don't have time to really present their case, but you should dig to see how deep their knowledge and understanding is of both the facts and the law. And on the law, they should understand clearly which legal instruments are important to this case and what provisions of those legal instruments are important. But they should go a step lower and deeper and demonstrate an understanding of the cases in commentary that have interpreted and applied those instruments. But they should then go deeper than that because these issues are issues that are not clearly decided in the text themselves or in the cases in commentary. And they should be able to state for you a policy that gives a foundation to the rationale that they are advancing in support of their client's position in the arbitration. Uh, in other words, they should help you write the award and make it well reasoned. At the end of the process, you will score them on a scale of 1 to 100. 90 to 100 is excellent. This is a pre-moot. They've still got a lot of work to do before the moot. So it's unlikely they'll be in that range. 75 to 90 is very good. 60 to 74 is good. That's probably where most of them will and should fall. Below 60 needs improvement. You can discuss with one another the range that you're thinking about for each advocate, but you should each provide individual scores for each advocate to be then submitted in the competition. Let's talk a little bit then about the problem. This year's problem involves the sale of electronic sensors. Uh, there is a framework agreement for which multiple shipments then will be made, and each shipment will require a separate, does require a separate purchase order. The claims brought in this proceeding involve two separate purchase orders. All of the substantive claims that will be heard in this hearing involve the first of those purchase orders. The procedural claims are brought by the claimant who has not received payment on either purchase order, but for very different reasons. On the first one, there was a breach of claimant's data, and that breach was used to fraudulently inform the respondent of a new bank account to which to send payment, and respondent did so. So claimant hasn't been paid, respondent has paid, but paid to the wrong bank account. And the question is that a breach by respondent? And does respondent still have to pay the full amount to the claimant? Or has the respondent fully complied with his contractual obligations? That's the first substantive question. Uh, and that's really the whole question on substance, but I'm going to come back to that. But the second purchase order, respondent didn't pay because respondent claims that the goods were non-conforming. So the claimant has made two assertions for purposes of the procedural argument. The first is that both contracts should be heard in one arbitration. This arbitration was brought only under the first purchase order, and claimant later discovered that payment had not been made on the second purchase order because of a number of things that happened with its employees and their presence in the office and otherwise to gather information. So claimant, wanting to have an efficient process, would like to have both decided at the same time. Respondent will, of course, say, well, they're very different questions. One is a matter of a data breach that claimant didn't let us know about, and the question is, did we pay to the right place? The other is a question of non-conforming goods, and that's a very different legal issue. But both advocates in the first procedural question, should be able to start in the ICC rules in Article 9, which deals with multiple contract claims, and track through the ICC rules through the contract. And Article 41 in the contract is going to be important to both procedural arguments. Clearly demonstrate an understanding of that text, but then demonstrate an understanding of the application of that text, both by commentary and case law. But more than that, they then should demonstrate a rationale, a policy rationale for you writing an award that comes out in favor of their client's position. So the claimant has requested that the two contracts be heard in this one arbitration. But the plaintiff has, or the claimant has an alternative argument that if the first argument isn't accepted, then claimant should be allowed to start a second arbitration on the second purchase order and consolidate the two and get to the same result. That requires tracking through a different part of the ICC rules, beginning with Article 10 of the ICC rules. It also gets into a question about whether it is the tribunal or the ICC court, which is a separate institution that makes its own decisions in the administration of arbitration. And so the students should be able to demonstrate to you their understanding of first who, under the ICC rules, has the ability to do that, how the contract, particularly in Article 41, affects that part of the ICC rules, and whether or not there can and should be a consolidation. The substantive claims, and all of this really comes out of our page 58 of the record, which is procedural order number 1, which gives us the issues you, the tribunal, have asked parties to address in this hearing. And that's not all of the issues that will be necessary for a final award, but it's what is the focus of this hearing. And the first question on the substance is whether claimant is entitled to payment of either the full or part of the amount. And it's likely that the substantive argument will be split into those two aspects, full and partial amount. So let me explain what the advocates should demonstrate an understanding of. The respondent is claiming that it fulfilled all its obligations under the contract, but that occurs only if the contract was amended to allow payment to a different bank account. And that amendment occurs only if there was proper agency, and there is no express agency for the fraudulent party sending an email, but there's an argument of apparent agency and maybe implied agency. And so both parties should be able to apply and understand concepts of agency to determine whether or not there was an amendment to the contract. And they should apply the rules of the UN Sales Convention, the CISG, on amendment. All of this will require interpretation of the CISG, and they should be able to walk you through, in particular, Article 7 of the CISG, which has the rules on interpretation of the convention, not of the contract, but of the convention. The respondent may argue further that the claimant breached in failing to disclose the data breach, breached an obligation of good faith performance of the contract. The claimant will tell you that there is no good faith obligation of performance of the contract in the CISG, because that's in the interpretation of the contract is in Articles 8 and 9, and there is no good faith obligation, and none anywhere else expressed in the convention. The only good faith obligation is in Article 7.2, and that's in interpretation of the convention. You, as the tribunal, have that good faith obligation. Moreover, the respondent will argue that the Equatoriana Data Protection Act should apply here. That's a verbatim copy of the European Union's GDPR, General Data Protection Regulation. And the question here is, A, whether this fits within the text of the Data Protection Act, and you should push them on that, and whether this type of corporate data breach and breach involving information concerning corporations falls under that act. But even further, then, whether it applies from Equatoriana to a party in another country. And this gets you into the whole concept of extraterritorial application or prescriptive jurisdiction or legislative jurisdiction. Can Equatoriana legislator legislate in a way that creates an obligation on a party in another country? That's a public international law question. It's been dealt with in other private party cases. In fact, there's a case from the Netherlands where one of the parties was named Censor BV, a Dutch company. And so you have to think about when the people wrote this problem, were they thinking perhaps about that case? Then the claimant is going to say, well, respondent never paid us. Respondent is going to say the contract was amended and we paid to the bank account that was appropriate given the amendment of the contract. Claimant will claim, but we are entitled to the full amount. Two articles of the CISG, though, will come up and should be dealt with by the parties. One is Article 80. Article 80 is an excuse for non-performance provision. And Article 80 says a party may rely on a failure of the other party to perform to the extent that such failure was caused by the first party's act or omission. And that will get tied into the question of extraterritoriality. Was there an obligation to disclose the data breach? If there was, then there was an omission that caused the respondent's failure to perform. And respondent then is excused. And they might go a step further and argue whether or not that excuse is complete or only partial. In the pleadings, the parties have also raised Article 77, which creates for the non-breaching party a duty to mitigate damages, to take acts that prevent further cost and additional damages as a consequence of the breach. And the question here is whether defendant's conduct then was a failure to mitigate damages. One of the questions that comes up here is whether or not Article 77 applies only when there is a request for damages and does not apply to a request for specific performance. And what is it the claimant is asking for? It is simple payment, it is specific performance. And Article 77 on mitigation of damages, given the structure of remedies in the CISG, which is a traditional civil law structure that goes with a preference for specific performance, there are commentators who say that Article 77 doesn't apply if you're dealing with specific performance. It only applies when you're dealing with damages. So I don't want to take too long, but I hope that's enough to get you much more interested in the problem and dig a little further, but enough to structure some questions that you can ask the parties in the hearings in which you will participate and help them in this wonderful educational process. And so let me simply end by saying once again, thank you. You are making a huge contribution to the education of these students, a huge contribution, I think, to the development of the next generation of lawyers in this region for international commercial law and arbitration. Thank you.